Welcome to What to Ask an Elder Law Attorney. This is your guide for caring for your aging parents. I'm Donna. I'm the mom in the middle. And if you're a woman who's caring for her aging parents, driving them to the doctor's appointments, handling medications, doing the day-to-day, maybe helping with the bills, or trying to figure out where to step into that, then this video is for you. I've been right where you are, caring for parents while juggling kids, career, and life in general has taught me one huge thing, and that is that you need to get your legal and financial, or their legal and financial affairs in order now, not later. It can't wait. I'm a procrastinator by nature. It will probably all work out by nature, despite my high levels of anxiety about all the things that could possibly go wrong. But this is something that really needs to be taken care of. I realized that we didn't even have power of attorney signed when my mom had a stroke this year. We had all been concerned for my dad, who was living with the effects of a stroke he had years earlier, and just all expected that my mom was going to remain the caregiver for him. And when they moved in with us, she's still his primary caregiver. We were just here for kind of extra eyes and extra arms when he needed to be lifted. We just assumed he would be the one who needed care. But what a year 2025 is turning out to be, when my mom had a stroke on New Year's Day herself. Thankfully without physical effects, but there are some mental effects and definite slowness and weakness that didn't exist before. So now we're caring for two people with various health issues. But I just want to say that the elder law planning really, really matters. It's not just for rich people. It's not just for somebody with a lot of property or art or things to leave behind. It's actually to have things in place for you to care for them in their final years. It's about protecting your parents and also your peace of mind, because let's be real, it's hard to manage all this stuff when there's anxiety or unanswered questions or worries or concerns hanging around. And without the proper legal planning, you could be stuck in making impossible decisions in a crisis, fighting with banks, fighting with hospitals, demanding doctors respect your wishes. Might even be fighting with siblings or other family members who think they know best or think things should be a certain way, when that may or may not be your parents' actual wishes. For example, bank accounts are frozen when someone dies or becomes incapacitated. If you're not on the bank accounts, you can't help them. You're stuck. There's no authority to make medical decisions. Doctors may listen to you, they may not. They may make the decision that is appropriate for their malpractice insurance and not necessarily the choice that is within your parents' wishes for their end-of-life care. There's delays in accessing life insurance if you're not named a beneficiary. If those things aren't up to date, there's probably always going to be some family disagreements, but certainly if a no will exists, it's going to be really tough to navigate those challenges. So here's what to bring up in your first meeting with an elder care attorney, which my parents and I actually just met with today. So it's fresh in my mind, it's fresh in instruction and things like that. So I just wanted to share. First of all, you need to know about wills and trusts. Which one's appropriate? I'm not an attorney. I am certainly not giving advice. You need to ask your attorney that question based on what the ultimate goals are with your parents. Who inherits what? Who do they want to get the things that they will leave behind? And then, does a trust make sense to avoid probate issues? Those are questions only an attorney can answer, and they can outline the pros and cons of each thing. Power of attorney. Do you need it? You might not. It sort of depends on the will, the trust, and how things are set up. So you do want to have the ability to make financial, health, and legal decisions if they're incapacitated in some way. That leads into the medical power of attorney or advance directives. My mom tends to think, because she has heard the doctor say advance directives before, that they have that. They don't. They've told the doctor that they do not want drastic end-of-life care, but that does not mean that that is the decision that will be made in the end. So it has to be written down. Then bank accounts. Are you on the bank account? Do you need to be on the bank account? How will it help or hinder if you are or are not? Can you take care of their bills if you're not? Those are questions for your banker. Asset protection, long-term care planning. Will they be in your home? Will they be in a long-term care facility? Will they be cared for in some other way? What are their wishes? What are their financial abilities? And then what are the requirements for that? An elder care attorney can give you advice on those things. Like I said, I'm not an attorney. I'm not giving legal advice. I'm just sharing with you questions that have come up for us and recommending that you do just what I've done. Ask friends, ask older family members even what recommendations they have for an elder care attorney in your area, and make that appointment. Make that appointment now, like today. If it's after 5, make it tomorrow, but it's important. You just should definitely do that as soon as possible. Then take your parents in and discuss what's needed for their individual situation. So let's talk about, for one thing, power of attorney. Without one, even as their child, you can't legally access their bank accounts, pay their bills, or even talk to their financial institutions or creditors if your parent becomes unable to manage their affairs. So that needs to be in place ahead of time, because you don't want to have to go to court. You don't want to have to ask for guardianship or conservatorship or those kinds of things, especially when you're dealing with a health crisis at the same time. A medical power of attorney or a healthcare proxy is another item that it's slightly different than a power of attorney or a durable power of attorney, because medical power of attorney gives you the authority to make medical decisions on a person's behalf if they're unconscious or unable to speak for themselves. And it's important on that note to know what your parents' wishes are ahead of time. Make sure that everyone is clear on what those are and have those documented so that everything's in line should you be the one who has to make decisions, especially if they are decisions that other family members do not care to make or do not agree with. That's really important. In the case of wills versus trusts, a will is a legal document. Most of us know that. It outlines how a person's assets should be distributed after their death, but it has to go through probate court. That can be time-consuming. All of that information is public. There are even cases, as the attorney told me today, where during the creditor claim period during probate, there could be false claims made. Like, say, a roofer is looking through the paper and says, oh, I'm going to say I put a new roof on their house. They're not here to say I didn't. And they can make a creditor's claim that has to be resolved through probate, which could cause delays. I don't know how often that happens, but that was just the example she gave us of false claims being made through the probate process from creditors looking for an easy payday. A trust, on the other hand, allows assets to be managed and transferred directly to the beneficiaries without going through probate. Often that makes it faster, a little bit easier, because everything's outlined ahead of time, and then it's also a lot more private. Those things are not published in the paper. They're not matters of public record with your county offices. And so that's potentially gives you more flexibility as well, especially useful if you're planning ahead for aging or unexpected circumstances. Just like for my case, a stroke caused a drastic change in mental faculties. So that stuff can happen very suddenly. Beneficiary designations also have to be up to date, whether it's on any insurance policies, life insurance, annuities, retirement accounts, any other investment accounts that your parents may have. If you go with a trust instead of a will, you'll need to ask the attorney as well as the account manager how that needs to be set up or specified within their paperwork so that they know how to disperse those assets at the appropriate time. And then you need bank account access in some form. Just like I'm not an attorney, I'm also not a banker. So you'll want to go with your parents to their bank and let them advise you on what the options are and what the best move to make is. In my case, just a couple of weeks ago, we went to each bank and I was added as a joint account member with right of survivorship. So that means that I have access to the bank. We didn't order new bank cards or new checks with my name on it because I don't need those right now. But that's an option in the future should it become necessary. And it also ensures that if anything does happen to either or both of my parents, that my name is on the account. So I am still able to access the bank account. The bank accounts are still open. They will not be frozen because I'm a third member on the account and I'm present and accounted for. So I encourage you, as well as with the attorney, to make that appointment today with the bank, make that appointment with the retirement accounts or the life insurance agent as well, to make sure that all these things are in order for you. Better yet, with the bank, you can do what I did. Take the parents out for lunch one day and just stop by the bank on the way home. Don't wait for anything to happen. Just drop in, make the changes that need to be made, and ensure you have access to protect your peace of mind and also help take care of your parents. I mean, there are some definite mistakes that I've seen families make that even our family has made. Number one, assuming that you can act in any capacity without legal documentation. My attorney today said that, you can make the case for next of kin, but that may be too late. They may have made other life-saving choices on their behalf. So you want to have those things in order and ready to go. Not updating your old wills. My parents' current will says that my brother and I are to go live with a family friend in the event of my parents' death until we turn 18. I'm 51. So updating those is really important, and keeping the dates and marriages and other things in line. Another mistake is not discussing final wishes. It's a difficult conversation, but it must be had. Another is relying on verbal agreements. They don't stand up in court, and they don't mean anything legally, and people change their mind, and hurt feelings and things like that tend to bring out the worst in people at the worst possible moment. So if you have everything written, you have everything legally documented, everyone's going to be in a better position. Last but not least, waiting until there's a crisis to call an attorney. If your parent is unconscious, incapacitated, or in an altered mental state, it's too late. They can't sign legal documents at that point, even if they're awake and talking. So you want to make sure that you speak to the attorney as soon as possible and have as much of this covered as you can. It can be really challenging to start this conversation. It really just kind of depends on family dynamics, but you want to have the conversation about end-of-life care as soon as you can, so you know what the wishes for your parents are. It's probably the hardest part, but you can start with simple things like, hey, Dad, I know you are still sharp and you are on top of things. That's why it's the perfect time to have this discussion. I want to know what you want the end of life to look like. And then wait and let them tell you. Or, hey, Mom, I just want to make sure that when the time comes, if something happens, if you need my assistance, that I'm helping you in the best way possible, that I'm providing the help that you want me to provide? What does that look like to you? What ideas do you have? Just open that door. It probably won't be a single conversation, it may be several. And just keep that communication open and approach the subject as often as possible until the legal aspects are taken care of. Just remember, I'm the mom in the middle. I'm doing this right now. I'm right here with you. You're not doing this alone. So I want you to know that you have a friend, somebody walking the same path, and it's important to protect you and protect your family and protect your parents and your peace of mind to get this taken care of. So I want you to like and subscribe, and that way you'll be ready to get more caregiver tips as I put those out weekly. And you can share with a sister, a friend, a sibling, somebody else in your realm probably needs this as well. So please do share. And then click the link below for your elder care legal checklist that I've provided so that you have a list to go by of these talking points. You know exactly what to speak to the attorney about, what topics to bring up so that you don't miss anything. And then if you have other questions, please drop those in the comments. I'm super curious to hear what those are. I'd love to take the time to see those, answer those, and create that discussion so that we can work together through this challenging season, but also knowing that you're not alone.